check the mics first here. Okay, we'll try that again. Wow, big crowd. Welcome to Northwestern University School of Law, here on a snowy day in February. That's for posterity, for folks watching this long in the future. We're delighted to welcome our distinguished visitor, Justice Elena Kagan, who is this year's Howard J. Trienens Visiting Scholar.
Thank you.
We're obviously joined by many guests, students in the law school, faculty, distinguished alumni, friends of the law school from all quarters. So to all of you, whether it's your first time here or you're a returner, welcome. Justice Kagan, who earlier in her career was here in Chicago, made Chicago her home, I will say welcome home.
Thank you very much.
Back to Chicago. A few words about the Trienens Distinguished Visiting Judicial Scholar Program, established by lawyers at Sidley Austin to honor the service of one of their esteemed colleagues, Howard J. Trienens. We're delighted to have hosted this now for, if you can believe it, a quarter century. Howard, is most of you know, is an alum of the law school, a graduate of the class of 1949. His association, he's former law clerk to Chief Justice Frederick M. Vinson. His association with the Sidley Austin law firm has continued for 6.5 decades, including a partnership that began in 1956 and leadership of the law firm in service as chair of the executive committee from 1977 to 1993. Howard Trienens' association with Northwestern University has also been quite long-standing and has included, among other roles, chair of the Board of Trustees and a wise counselor to a succession of law school deans, present company included. Over the course of a quarter century, we've been privileged to host a number of distinguished jurists from around the world, just to mention those from the court upon which Justice Kagan sits. Chief Justice William Rehnquist was our first visitor in 1990. We've also welcomed Justices John Paul Stevens, Sandra Day O'Connor, Chief Justice John Roberts, Anthony Kennedy, Ruth Bader Ginsburg, and Sonia Sotomayor. So Justice Kagan, you are our lucky number 8. One more and we'll have a complete court. A few words about our distinguished visitor. Justice Elena Kagan was nominated to the Supreme Court by President Barack Obama in 2010 to fill the seat of retiring Justice John Paul Stevens. She was confirmed that summer and took her seat beginning with the October 2010 term. Before joining the court, Elena Kagan was Solicitor General of the United States. Her other previous stints in government service included domestic policy advisor to the Clinton White House and earlier in her career as a judicial law clerk to Judge Abner Mikva of the D.C. Circuit and a Justice Thurgood Marshall of the Supreme Court. She has had a distinguished career in the legal academy, serving first as a member of the University of Chicago Law School faculty and then later as professor of the Harvard Law School. She served as dean of the Harvard Law School for several years beginning in 2003 and was, I can say, as an alum, a truly remarkable dean and leader of that law school. Elena Kagan is a graduate of Princeton and of Oxford and received her law degree from Harvard Law School. As a point of personal privilege, I was fortunate to attend law school with Justice Kagan and served on the law review with the Justice. She was the lead editor on my student note, and I can say with the vantage point of a quarter century, I still bear the scars of that experience. So without further ado, let us all welcome Justice Elena Kagan to Northwestern and say we look forward to this conversation.
Thank you. Thank you.
So consistent with this intimate fireside chat,
Yeah.
I'm going to ask you a few...
Just you and me, right?
Just us. Pretend this third wall. I'm going to ask you a few prepared questions, and we'll have some time at the end to hear some questions from the audience. Just to get the suspense out of the way, I'm not going to ask you anything about cameras in the courtroom. I believe you have some views about that. You can check the internet for those views. So while I won't ask you about that, I'm going to ask this question in the most formal Supreme Court justice's way I can. What's up with the hunting trip with Justice Scalia? As the kids say, what's up with that?
Okay, I will answer that. But before I do, I just want to say how delighted I am to be here, how honored I am to be at the Howard Trienens lecture. I mean, he's an extraordinary man, Anybody who has ever lived in Chicago knows about Howard Trienens, and anybody who has ever, thought about or been part of the legal profession knows the great work that he did as a lawyer and as really just a figure in this community, not just Northwestern, but Chicago and the whole legal profession. So it's a real honor to be here. And it's a great pleasure, Dan, to be here with you. As you say, we go back a long way. We were at Harvard together. We were 1 year apart. We were on the law review together. And I've sort of watched Dan from afar since then and seen this meteoric academic career and decano career. And deans watch each other. And Dan has been, is now just a truly superlative dean, and Northwestern is lucky to have him. So it's great to be here. So thank you very much.
Let's stop right there.
It was even worth the blizzard to get here. So the hunting trip. I went hunting with Justice Scalia just before Christmas. We went to Mississippi together. We did an event like this at Ole Miss, and then we went out hunting. It was not at all the first time. So I'll tell you the whole story. The story goes back to my confirmation. And when you go through the nominations process nowadays, you're asked a lot. At least I was asked a lot, and I think people like me with my kind of profile are asked a lot about guns, about the Second Amendment. But nobody can really ask you straight out what you think about these legal issues, what you think about the particular cases that the court has decided or anything else. So they have to figure out ways of, proxy questions to try to get at your views and to try to figure out whether they're comfortable with you. And as I went from office to office to office in the Senate, I did, in the end, about 82 courtesy visits. And I swear it seemed like 77 of them, Republicans, Democrats, were all asking me this set of questions. And they went kind of like this. They would go sort of Second Amendment, very important issue for people in my state, and I'm concerned that about your views on it. Have you ever hunted? And I would say no. And they would say, does anybody in your family hunt? And I would say no. And they would say, do any of your friends hunt? And I would say no. And they would say, do you know anybody who hunts? And I would say no to that one too. And I was pretty. It was pretty pathetic, really, because I was this Jewish girl from New York City, and this is really not what we did on the weekends. So I kept on being asked these questions. I knew I was failing miserably at them, and I'm sitting in a senator's office. It must have been my 60th office visit. I was feeling a little bit punchy. And he started off on sort of a similar set of questions. And I should say, by the way, that, I completely understand why it is that people care about this set of issues. And the senators are all hearing from their constituents who do care deeply about this set of issues. And you understand why they're asking about them. But he was sort of talking about the hunting that he did on his own ranch and what he hunted and why it was important to him and what he was concerned about with respect to the court's Second Amendment jurisprudence. And as he was talking about hunting on his ranch, and asking me this kind of like, have you done this? Have you ever done this? Do you understand why it's important? I said to him, Senator, I've never had the experience. I've never really had the opportunity to do it. But I really would love to have it. And if you would like to invite me to go hunting on your ranch, I would come in a heartbeat. And this look of abject horror passed over his face. And the White House aide who's sitting next to me on the couch is about to keel over, And I thought, okay, I've probably just stepped over some line. I've gone too far. Back it up. And I said, Senator, I really didn't mean to invite myself hunting with you. I said, I totally understand your concerns. And if I'm lucky enough to be confirmed, I'll tell you what I'll do is I promised to ask Justice Scalia to take me hunting because I knew that Justice Scalia is a very avid hunter. And so when I did get confirmed and when I got to the court, I went to Justice Scalia's chambers and I told him this story, and he thought it was hilarious. And I said, I said, this is the only promise I made in 82 courtesy visits. So you have to help me out with this. So he was great. He took me to, he has a member of a gun club. He took me to the gun club, and we shot clay pigeons for an afternoon until I got comfortable with it, until I understood about safety issues and just got comfortable with the whole thing. And then he has this group of hunting friends who are incredible guys and very generous to me, and they started inviting me hunting. And we go hunting, we go like quail shooting a couple of times a year. I guess we did it 2 or 3 times in my first year on the court. And then at the end of the year, he said, it's time for big game. None of these little birds, So we went out to Wyoming together the next year, and we shot deer and antelope.
You shot Bambi.
I shot Bambi, it's true, yeah. We couldn't find any antelope, but I shot Bambi. Sorry for any of you who that makes squeamish, And then, we've continued to do it. We go out a couple of times, 2 or 3 times a year. And this year he said, you will love duck hunting. So we went to Mississippi and we went duck hunting. And he's right. I thought duck hunting was kind of great. So,
well, thank you.
So there you are. There's my hunting story. That's what's up.
That's great. Well, lest this be a love fest with you and your able colleague, Justice Scalia, let me try to drive a wedge between the two of you and ask you not about duck hunting, but about a State of the Union address. So you were talking about this earlier. So just last week, a couple weeks ago, we saw you and 5 of your colleagues, not all of your colleagues, there in the front rows at the President's State of the Union address. So I want to ask you 2 questions about this. One is, what is it like being a recipient witness of this remarkable and deeply political event? The other question is, what do you think of the critique, including by some of your colleagues, that there is something unsettling about justices attending? Justice Scalia, for example, called it, quote, a childish spectacle, something he didn't want to lend dignity to.
Yeah. So we're divided on this. The 6 of us show up every year. Since I've been on the court, I think 6 of us have gone every year, and 3 have decided not to. And I totally understand why the 3 who have decided not to go have made that decision. Because you do go there and you feel kind of out of place. It has become a very political event, a very partisan event, to the extent it ever was, and I'm not sure it ever was, but to the extent it ever was a kind of state event, if you will, I think it's lost that character. It's become very partisan and political, and that puts the justices in an odd situation. It also actually puts the Joint Chiefs and military officers who are there in an odd situation. I'm always the person who sits next to, we sit by seniority, and I'm always the person who sit next to the Joint Chiefs, and we always sort of have jokes about, well, it's time for us to act the potted plant, and all of us do, except they get to stand a couple of more times than we do, because they get to stand at all the talk about honoring the troops and the various military engagements or whatnot, and we don't even really do that. So we just sit and stare straight ahead, and to make it, sometimes senators sit behind us and they sort of chat through the whole thing, and so in your left ear there's I won't name names, but there's some senator making snide or glowing, as the case may be, remarks about what they're hearing, and it all does seem like, why are we here exactly? And so now you're wondering why I go, and
exchange hunting stories with the Joint Chiefs of Staff.
I don't know. I guess I go, and the 6 of us have decided to go because it is a tradition that, and the tradition is to have the whole government come at this one time a year, and even if the Congress has become more partisan and the event has become more partisan, still I think there's something to this sort of event of state where the entire government gets together and the American people get to see them all. And I have to say, there's part of me also that sort of thinks that the spectacle of it all is kind of interesting, maybe as much as an anthropological matter as anything else, but, as an opportunity to sort of see the rest of the government, whether it's the president's cabinet or the president or the members of the Senate and the House and the Joint Chiefs and others all there. And there's something sort of impressive and glorious about that until like everybody, like half the room stands, the other half boos, and that seems a shame. But it's a kind of interesting event in which we have no particular place, but there we are anyway.
Thank you. Let me ask you about the composition of the court upon which you sit. So 8 of the 9 justices are graduates of 2 law schools, Harvard and Yale. I think Justice Ginsburg is a graduate of Columbia.
You lost Justice Stevens, from the court.
We'll get there. Don't worry. That's on my list. Yes. But thank you for that. But currently, Harvard, Yale, and Columbia, and you've heard the critique that the Supreme Court comes from that elitist background, and indeed a very narrow background because of their prism through those law schools. What do you make of that critique?
Yeah. So I think it is unfortunate, but maybe not for the reasons that some people say. I don't think it much affects our decision-making. So the idea that somehow these people are being trained in a certain way at Harvard and Yale, and we would have a different court if we had people who were from many more law schools, I don't know. I doubt that there's anything very different about the training that the members of the court have received in those 2 institutions, from many others, from Northwestern, from many others, both elite and non-elite. So I don't think it much affects the decision-making of the court, but I do think it's actually unfortunate just in the way that any lack of diversity is unfortunate. And I guess I would make the same point about other kinds of diversity, whether it's racial or gender or religious or whatnot, that I think it's actually a lot less important in terms of decision-making. And the reason that it is important has to do with the way people perceive the institution. And that there's something to be said for having an institution that, in some sense, reflects the country that the institution serves, and for having, with respect to this issue, an institution that, in some sense, reflects better the legal profession and the variety of different schools that lawyers around the country come from. And as I go from place to place, I hear this question quite a lot, and actually much more poignantly, I think, not from places like Northwestern, which are elite law schools, and the great Justice Stevens went here, and one, you will soon have another, but from law students in places that are a little bit less the top of the top of the top, and sort of wonder, as they look at our court, whether they can aspire greatly in the legal profession. And I think that that's a shame, and it would be a great thing, I think, if there were more. I say this with a little bit of heartache because there's still some part of me that's the dean of Harvard Law School, but not much of me anymore, honestly. These things come and go, Dan, I'm looking at Newt Minow in the audience, and it's like it's his daughter's problem now. So mostly I think it would be really a great thing if there was more diversity of legal background.
Great, thanks. So let me ask you, this is out of order of the questions, but Justice Stevens' name has been come up a couple times. So I want to ask you what is any way you slice it, a Northwestern-centered question, which is you occupy the seat that Justice Stevens was on for many, many years on the court. And I just wonder if you would share with us a little bit about how he's helped you in your transition to the court, particularly when you were just appointed.
Yeah, well, the first thing to say is I absolutely love the man. And the one thing I regret about replacing him is that I've never had the opportunity to serve with him. Because from everything I've seen and from everything I've heard, I mean, he seems to me like he would have been the most extraordinary colleague. I mean, this is a guy, he's brilliant, and he's nice. I mean, like Midwestern kind of nice. And yet so sharp and so effective. And to be nominated for his seat was an incredible honor for me. To be nominated to the Supreme Court, of course, is an incredible honor at all. But then to be nominated for Justice Stevens' seat, and people do think about this. When we come onto the court, we get this like pewter cup, and all the justices who have sat in your particular seat are engraved on the cup, and the first name on my cup is John Paul Stevens, and I think that's a kind of amazing thing. And he was terrifically helpful to me. I mean, when I got to the court, he came in, he offered me like all the stuff that his clerks had provided to him the prior year for the cases that were going to be argued the next year. He's been really no end of generous in terms of if I ever had a question about how the court operates or what I should be thinking as I join it. He's a fount of wisdom. He's a fount of good advice. I mean, you guys are awfully lucky to have him as an alumnus. He is a credit to your institution and an extraordinary human being.
Well, thank you. Absolutely. By the way, if you want to sit literally in his seat, I know where to find it. It's
I saw that.
So sort of carrying on that theme, would you describe to us some of your heroes, whether in the law or outside of law, and what they've meant to you?
Well, gosh, I mean, I think that the first couple of people I have to mention are the people I clerked for. You're clerking at a time, really a formative time in a young lawyer's life, and I had two incredible mentors. The first was a great Chicagoan, not Northwestern, University of Chicago, but Ab Mikva, who was a congressman from the Hyde Park area and then became a judge and then served as the counsel to the president for President Clinton. So one of the only people, maybe the only person, to have served at that kind of level in all three branches of government. And, incredibly intelligent, an incredibly great lawyer, an incredible public servant, somebody who just lives and breathes public service, always trying to always asking himself what he can do in his life for the community that he lives in, for the nation that he lives in. And to have that kind of role model was a great thing for me early on. And not just to have that kind of role model, but to have that kind of mentor. I'm quite sure my first job at the University of Chicago just wouldn't have happened had it not been for Ab Mikva, getting on the phone and calling all the people he knew and saying, here's what I know about Elena Kagan and why you should hire her. And, there are a lot of people who I can point to in my life and say, I wouldn't be where I am today except for that person. But maybe he's number one on the list because of how early that was in my career and how important it was. And then, indeed, he had me back to when after I had spent time at the University of Chicago, he called me one day and said, "I'm going to be counsel to President Clinton. Come work for me." And I went to the White House because of him, and that was an incredibly important part of my career, important for me personally and for me professionally, one of the great experiences of my lifetime, and that too I owe to him. The second judge that I clerked for was Thurgood Marshall, and that was an extraordinary experience as well, of a somewhat different kind. I mean, here, clerking on the Supreme Court is a kind of heady experience for a young person. You come out of law school, and there you are, and you're at the court, and all these important cases, and you're somehow a part of them, and it's a pretty heady experience. But then, to not just have that, but to be working for the person who I think was the greatest lawyer of the 20th century, bar none, not even a close contest, the person who did most in our time to advance justice in our society. And I clerked for him at a time when he was approaching the end of his career. He wasn't all that well physically. I think he knew he was approaching the end of his career and indeed his life. And he was a little bit looking backwards or taking stock, I would say. And so I had this incredible experience where my co-clerks and I would go into his chambers every day, and we would talk about the cases to start with. And he was a really sharp lawyer. He had this knack for just really seeing to the heart of something and stripping away all the stuff and getting to the essentials. And so we would talk about the cases, and I would learn a lot about lawyering in those conversations. But then at a certain point in time, he would kind of switch over, and he would switch over into storytelling mode. And he had unbelievable stories to tell. I mean, from his childhood and his education, and then on into all the years that he spent at the Legal Defense Fund, and doing this incredible work, being this incredible appellate advocate who led the way to Brown v. Board and desegregation and not only of the schools but of all institutions of our society, but also an incredible trial lawyer, a person who just sort of crisscrossed the segregated South and appeared in these towns where he would represent people who were charged with extremely serious crimes, murder or rape or whatever, where there would be always an all-white jury, not necessarily ready to dispense real justice, where it wasn't only the kind of hassle of being a black man at that time, unable to eat at restaurants, to use public bathrooms and so forth, but the kinds of stories he told about, the physical danger that he was often in as he did this work were sort of life-changing stories for me. And it was just a sort of opening a window onto this incredibly important part of history, of this nation's history, of the role that law can play in removing some fundamental injustices, and of the role lawyers can play. And that was very inspirational to me, and continues to be.
Great. Thank you very much. Let me ask a few questions about the Supreme Court and its work. So the Supreme Court hears, again, that you've heard this critique, fewer cases these years than in past years, and some criticize the court for taking too few cases, thereby leaving major issues and conflicts between and among circuits unresolved. Do you think this is a valid critique? And what is the consequence of any of the court considering a relatively smaller number of cases?
Yeah, it's absolutely true. When I was clerking on the court, and that was about 25 years ago, we took about twice as many cases. So there was a pretty steep decline, and it almost seems like it was a cliff. It wasn't even gradual. It just kind of happened, and nobody quite knows why it happened. And I think all of us think that as an abstract matter, we could be taking some more cases. I don't think anybody would go back to the time when we were taking twice as many. I think most people who were on the court then thought it was too much, that there wasn't sufficient time to be able to give some of those cases the attention that they deserved. But I think all of us feel we could do more at this point, and maybe ideally should. But I think it wouldn't be, I think I would say, and I think my colleagues might agree with this, that we think that abstractly, but then as we look week by week by week at the cases in front of us, I never really get the feeling that we're leaving a lot of cases untaken that we ought to be taken. I mean, I never really feel as though, there's this wealth of cases out there that we're just refusing to take. We almost always take cases where there's any well-developed circuit split. We take some cases where there's no circuit split just because we think they're important. And, we take cases that are not particularly glamorous, that may not even be particularly important just because there's a division. I think we almost always take those cases. So I guess I'm a little bit hard-pressed to think, what are the cases that we're not taking that we should be taking? And for me, it's not easy to answer that question. So we end up, I think, in this pretty steady state, about 75 to 80 cases, when I suspect all of us think we could go up to 100 or so, but the cases don't seem to be there for whatever reason.
Let me ask, certainly many law professors, many lawyers, including some in the audience, are often asked to author or to sign on to amicus briefs, amicus curiae briefs, friends of the court briefs for the Supreme Court. So I want to ask you what role those amicus briefs play in the court, and in particular with you. I mean, obviously there's quite a lot submitted, particularly in high-profile cases. And how would you say that those kinds of brief influence outcomes in cases?
I think it really varies. It runs the gamut. Sometimes they don't affect the outcomes at all, and sometimes an amicus brief can be extremely important. So, I mean, you're exactly right that in these high-profile cases, we can get tens and tens and tens of them, 50, 60 cases, 50, 60 briefs, too many to really read. And one of the things that I ask my clerks to do for me is that they have to read every single one of them and tell me which are the ones that are important for me to read. And they can be important for a number of different reasons. I mean, sometimes you might have a case where the merits briefing just isn't very good. In other words, where the party's own briefing, just for whatever reason, isn't very good. And an amicus brief can be a kind of substitute party's brief, presenting the argument better than the party, him or herself, has made it. But other times, an amicus brief sort of adds something new. The party does the basic legal analysis, but then there can be an amicus brief that can add sometimes that's often a sort of the way the world works sort of brief. You have the legal analysis and all the doctrinal arguments in the main briefs, but then the amicus briefs come along and say, in order to really decide this issue, you have to understand how this body of law actually operates in the world. And a sort of more practical, on-the-ground sense of what the effects of different decisions are. So sometimes those briefs can make a difference. Sometimes briefs can make a difference if they add a different theoretical component to the debate. And sometimes, law professors and economics professors, by the way, are good at making these kinds of briefs. I remember there was a case last year that concerned an issue of securities law relating to the fraud on the market theory. And this was a theory that had been developed by academics and incorporated into securities law. And the question was essentially whether it had been incorporated in the right way or whether it should be ditched altogether. And there were very important amicus briefs talking about the validity or the non-validity or the limits or the non-limits of the fraud on the market theory. And of course, that came into the merits briefing, but it was, but you wanted to be able to look at the amicus briefs as well for a really fuller description of those kind of academic theories that had informed the doctrinal issues. Mm-hmm. So the amicus briefs can matter, and then sometimes they matter not at all. Sometimes it's just like a repeat of the parties' briefs, but not quite as good, or just as good, but a repeat. And it runs the gamut.
Interesting. So in recent years, Supreme Court advocacy has become a rather distinct specialty, with a relatively small number of lawyers in government and in private practice arguing most of the cases, and certainly most of the controversial cases before the court. So could you comment on how this has affected, if at all, the quality of the advocacy before the Supreme Court, and do you think this trend will continue, and is it a good or a bad thing?
My guess is that we all hope that it will continue. Because I think all of us think, at least I think, and I suspect my colleagues, that good lawyering helps for better decision making. If you have the arguments presented to you in an effective way, it enables you to really see what's at stake and what the issues are and what the arguments are, and enables you to make a better decision. And I think one of the things that district courts and circuit court judges are often jealous of is that we really do get cases, to some extent, prepackaged for us. Here are the issues, here are the arguments. It's not as though we can't go beyond that or don't, but the clarity of the way the case is presented to us, I think, helps us to make informed and good decisions. And I think that that's what the Supreme Court bar now does. It has become very professionalized. It's become smaller. We see repeat players, people who argue 2, 3, 4, even 5 cases a year before us, people who understand the sort of questions we ask, people who give us the information that we need and want rather than something else. I mean, there can be really terrific lawyers who just aren't really appellate lawyers and aren't Supreme Court lawyers. Sometimes you'll see a case where the trial lawyer comes in and does the Supreme Court argument, and occasionally it will be fine. Occasionally it will even be really good, but often it won't be, and because the person might have great skills for a trial lawyer, but just not have the experience or the skills necessary in order to do appellate advocacy, and especially at the Supreme Court, where I think appellate advocacy is incredibly hard. We are a really hot bench. We bombard people with questions. We barely let them have a chance to talk. And in order to break through with an argument on this court, you have to be a lawyer of very special and specialized skills. You know, there can be some great lawyers who don't have those skills, and I think better to give these cases to the people who do. And the only thing that troubles me about it is that sometimes you see real disparities between lawyers, between parties who are represented by these kinds of lawyers, very experienced, very skilled, and parties who aren't. Now, I think that does not really have to happen all that much. Even for people who can't afford the rates that these lawyers charge, a ton of these law firms are doing this kind of as a loss leader practice and will do cases free.
Some law schools,
and
too,
there are law school clinics, including Northwestern's, and many other really, truly excellent clinics, with often working with law firms, sometimes not, but really doing quality representation. And the place that this concerns me most, honestly, is as to criminal defendants. I mean, as to other cases, you know, when it's like business against labor or business versus consumer groups, or, I mean, it seems to me like they are being represented really well on both sides. The place where this sometimes isn't true is with criminal defendants, where the states, certainly the federal government, but even the states, which used to be maybe not quite at the highest levels of appellate advocacy, now really are. They all have Solicitor General's offices. They all do their advocacy at a really excellent level. And I think that sometimes it's the criminal defendants where the trial lawyers are not ought to hand over the cases to the Supreme Court experts, and maybe are not doing that as much as they should.
Interesting. You talked before about your experience as a judicial law clerk. Could you talk a little bit about how you use your law clerks?
Yeah, so, I mean, one of the great parts of the job, and especially for people who were teachers, is having these 4 people, and they're really smart, and they're really eager, and they want to be there all night and do everything. And so, you know, so I do use them, and sometimes they are there all night. So, certainly they do a lot of research for me. I talk to them constantly. I talk to all of them about every single case. We all get together in my office, the 5 of us. There's always one lead clerk, but I want to hear from everybody. I want them to disagree with each other. I want to hear what opposing arguments sound like. The only times I've ever been frustrated with my clerks are when I felt as though my clerks were echo chambers, and they were just sort of like repeating. Everybody thought the same thing, and everybody thought what they thought I wanted to hear. And I really don't want to hear that quite at all, that I hire these people. And I actually try to hire a spectrum of different opinions, people who I think will approach cases differently from each other and differently from me. And I want to hear a lot of different views, and I want to hear people arguing with each other, and it's part of the way that I come to a decision. So that's one important part of...
So let me just interject. You've had conservative law clerks?
I have, yeah. I mean, yes, certainly so. And, you know, I like that experience. And sometimes there have been a couple of years where that hasn't been the case, where I felt like everybody was like me or to the left, and I thought that was bad. So I try to hire clerks from lots of different kinds of judges, and we'll continue to do that. The other thing that I use them for is to help me with opinion writing, and I do my writing basically by myself, but I make them write a draft anyway. Sometimes I say to them at the beginning of the job, "You have like the worst job in the building. Like you're not going to see your sentences in the U.S. reports, but you're going to have to write a draft anyway." And because the draft for me is very helpful in terms of stimulating my own thought process, serving as a kind of launching pad for me to really think through a case, serving as a kind of research memo, essentially, something that collects all the sites and all the, and something that sort of shows me how one person worked her way through a case so that I can kind of see what worked and what didn't work. But then I sit down and I kind of, I start a new document, and I start an opinion on my own, and I write my way through it. I have all the briefs there, I have all the cases there, and I write my way through it. And I do that, I've had clerks who are great writers, but, they're not writers that sound like me, and I want a Kagan opinion to sound like a Kagan opinion, across opinions, across years. Mm-hmm. And the other thing is for me, and I'm sure this is different for different people, but I'm never going to understand something as well by editing somebody else's work as I do by writing it myself. That there are 1,000 things that I think that I think I would not realize were real issues if I were just editing, that I do realize it as I try to work through the opinion in my own mind. But then I turn back around and I give my draft of the opinion to my clerks, and I really tell them to mark it up. And we go through a couple of different, several different rounds. Lead clerk first, then the rest of the clerks, but their job is really to improve everything about my opinion. Certainly to stop me from making any mistakes, but to make it better and to make it, more accurate and better written and all the different kinds of ways. And I love working with them on that.
Great. Well, it takes us a little bit into judicial philosophy. So one of your former Harvard Law colleagues, Cass Sunstein, wrote a number of years ago that judges, and perhaps especially justices on the Supreme Court, should decide on narrow grounds wherever possible. As he put it, the court should follow a practice of so-called judicial minimalism. And more recently, a number of prominent scholars have urged an even greater humility and even narrowness in approaching some of the more controversial issues of our times. So what do you think of this normative view? Is Professor Sunstein right, wrong?
Yeah, well, I think that there's a lot to it, which doesn't necessarily mean that it's true in every case, but that it may very well be true in a lot of cases. That to the extent that you can minimize conflict, and I think you can generally find more common ground if you go narrower than if you go broader, and there's a lot to be said for finding common ground and for taking incremental steps. I think typically law works best actually when it works incrementally, when it works kind of slowly but surely. And law can accommodate lots of change, but change that happens gradually and over long periods of time, usually, not always, but usually. So I think that there's a fair bit to be said about that approach. I think that there are a number of people on the court who really try to see if we can forge consensus, and that generally means forging it by going a little bit more narrow and finding the areas of agreement and leaving out of the picture the areas of disagreement. It's not always the case that you can do that. Some cases aren't presented in ways that easily lead to that. There are some cases in which if you could go more narrowly, but it would be a little bit artificial. It still leaves the real question on the table, that everybody understands. You're just like kicking down the road for 6 months or something. And sometimes that doesn't seem to make a whole lot of sense. Sometimes when a case is there, when it's been well briefed, when the broader issues have been argued, it makes sense to decide those issues rather than to take off a little piece of it and keep everybody in uncertainty and in doubt about the rest. So I think it really depends on the issue and the way it's been presented and the way it's been briefed. But, I think in general, it's better for law to move gradually and incrementally, and it's better for the court to achieve consensus than not. Doesn't mean it can always happen. Doesn't mean it's absolutely always the right approach to a particular case. But I think if we all have that in our minds as something that's more often the right way to go than the wrong way to go, it will be better for the development of the law, and it will be better for the legitimacy of the institution.
Great, thank you. Let me if I may, take you away from the court just for a couple moments and ask a couple questions about legal education, something you're familiar with. So these are very challenging times for legal education generally, as you know. At many law schools, including some of our leading law schools, there's been a downturn in applications, and there are challenges for graduates in legal employment. And more generally, there have been a growing number of criticisms in the media and in the blogs of legal education, asserting that law schools are too expensive, too insular, too remote from practice. For some, the entire model is broken and must be reinvented root and branch. Will you comment on some of these raging controversies or issues about legal education?
In a way, I don't feel I know enough. I mean, I was the dean of one school, one particular kind of school, and I was the dean, quite honestly, in like the boom years. I knew when to get out. 2003 and 2009, those were pretty much the best years to be a dean. Yeah. And so I haven't had to confront the issues that the deans since really 2008-09 have had to confront in terms of confronting a differently structured legal profession and declining applicants and so forth. So I feel as though it would be the wrong thing for me to do, to be telling the people who are in it what to do about it. I will say this, that I do think that somehow there ought to be more than one mode of legal education. That it's just not necessarily the case that if the top law schools are doing one particular thing and charging a certain amount of money, which is actually quite a lot, extraordinary.
Cover your ears.
It did always strike me that sort of everybody following the same model, when the students in these different schools had very different kinds of opportunities afterwards. If you look at the students in certain schools, the kinds of jobs that they have available to them upon graduating, the kinds of money that they'll be able to make, and then you compare that with other schools. I mean, the idea of everybody charging the same amount, everybody trying to give the same kind of education, seems not a sensible one to me. That there ought to be sort of different ways of providing a legal education that reflects who the market for your students are, and that's reflected in the kind of tuition that you charge. And I never quite understood why the elite law school model was the only one.
Great. Let me ask you about your exposure to the media and blogs and all of that. So you commented earlier today when we met that you do pay some attention to. I mean, at least you're a consumer of what's going on in the world, and reading the newspapers and the blogs means reading about views about you, about the Supreme Court, about the justices. Does it make any difference in your judging, in your performance on the court, what you read about yourself and about the court?
Yeah, I mean, I don't think what you read about yourself. I mean, some people like what you do, some people don't like what you do. It's sort of interesting to know, I guess, from a curiosity standpoint. But you have to expect that, and the more important the thing that you write is, the more that will be true, that there will be division. Some people will be thumbs up, some people will be thumbs down. Honestly, I don't really care about either. I am a consumer, as I told your faculty today, of some of the appellate law blogs. mostly because I find that sometimes there's an interesting idea in them. Sometimes I'll read something that some law professor will write, and I'll say, well, that's an interesting idea that wasn't in the briefs, or that wasn't in the briefs in the same way or to the same extent. And I'll ask one of my clerks, go track that down, go see what you can make of it. And I think it would be very rare for me to say that some blog post has reshaped what I think about a legal issue. But it's not entirely unheard of that something that's written in a blog you can hear it sometimes in the questions that we ask at argument, that we're asking questions about an argument that we actually didn't read in the briefs, that we read on the Volokh conspiracy or balkanization or one of the other.
Bill or some other blogs.
Yeah, there you go. So I think that they're helpful and interesting without being very life-changing.
Great, thanks. Now, this is fair warning. I'm going to ask a couple more questions, but those of you who want to have an opportunity to ask the justice, if you could line up at one of the two mics right there. So this is your few-minute warning. So, for all that we know or think we know about what it is like to be a justice on the Supreme Court, the court and its justices remain a remarkably mysterious institution in this country. So you're cloistered in many respects, and appropriately so, from public attention. Oral arguments in the court remain untelevised. All right, so I asked part of a question about cameras in the courtroom. And justices are very circumspect about commenting about major controversies in society. Yet at the same time, Supreme Court justices are important public figures, often recognizable, profoundly influential, and significant role models, especially for lawyers. So let me ask you, how do you think about your role as a public figure? And what are the positives and negatives, if I may, about the celebrity status of being a justice on the United States Supreme Court?
Well, honestly, I don't feel much like a celebrity, and that's good, because I don't really want to be a celebrity. I walk down the street, not all that many people recognize me, even in Washington, D.C. I lead a very normal life. I think that that's true for most or all of my colleagues, and in my book, that's a really good thing. I wasn't quite sure that that's the way it would turn out. When you're nominated and you go through the confirmation process, and your picture is all over the newspapers and on the evening news and stuff like that, then everybody really does recognize you. And at that moment in time, I thought, oh my gosh, my life really has changed forever. And it didn't seem, it seemed like it was worth it because this was an extraordinary honor to serve in this capacity, but it didn't seem like a very good thing when every time I walked out of my apartment building, somebody would ask to take a selfie with me, And people are no end of nice. I have never had a bad interaction with people. Mm-hmm. But, on the other hand, you would like to just, show up to Starbucks wearing whatever you're wearing without fearing that it's going to be, broadcast to the world or something. So that's been kind of a nice thing about what I found is that, 6 or 8 months in, everybody forgot what I looked like. Which is okay by me.
But everybody remembered the Chinese restaurant on Christmas Day story.
Yes, and every Christmas I get lots of emails.
Do you really?
Yeah, oh yeah.
Can you tell the story just because there might be a few people who
don't know it?
The confirmation.
Yeah, so this was during my confirmation hearings, and Senator Lindsey Graham, was asking me questions. He started off by it was a set of questions that was going to become questions about national security issues, but it started out by talking about the Christmas Day bomber, if you remember that. And the way he started out, he basically said, where were you on Christmas Day last year? And first I jumped right to the, this national security thing. And Senator Graham, properly, rightly, basically told me I hadn't really listened to the question very hard. He said, no, really, what I want to know is where were you on Christmas last year? And I said, Senator, I guess like most Jews, I was probably at a Chinese restaurant. And I have to say, the press corps in back of me, you could tell that they were kind of falling off their chairs. They were, and Senator Graham said to me later, he said, well, that was the moment I knew it was all done with. You were going to get in. And then there ensued, like amidst the general hilarity, a senatorial discussion about why it was the Jews ate Chinese at Christmas. Senator Schumer had his theory, and then but sometimes I think, here I am. I'm a Supreme Court justice. I write all these things, and I give talks, and however many years I do this for, the thing that people are going to best remember is this eating Chinese on Christmas line.
Yep,
it's a little bit upsetting, really.
Keep bringing it up. So here you are as a Supreme Court justice. If President Obama had not nominated you to the court, what do you think you would be doing professionally today?
Oh, that's an interesting question, and it just shows you how life takes strange turns. And I'll put it back a little bit. Rather than say if President Obama had not nominated me to the court, I will say if President Obama had not nominated to be Solicitor General. Because once President Obama nominated me to be Solicitor General, then I thought, then you know that there's a possibility that you're going to be on the short list, that you're going to... But if he hadn't nominated to be Solicitor General, I think I wouldn't even be doing law today, quite honestly. There I was a dean at Harvard Law School. I had been, I'd loved being a dean, and I had been, I think a good dean, and I would have stayed at Harvard Law School for some number of more years. And then one of the typical things that law school deans do is that they go be university presidents. And I'm about 98% sure that if I had not been nominated to be Solicitor General, that's the route I would have followed, rather than sort of going back and becoming a law professor again. And it just sort of shows you how weird life can be, and how little things can make big differences, and how life can change in a moment. I'm extraordinarily grateful to be doing what I'm doing. I love doing law. I love being a judge, and to think that maybe I would have not been a lawyer at all, but is a funny kind of thing.
Great, thank you. Okay, so we do have some questions. If I could just ask the speakers to identify yourselves, and so please, to the right.
Is it working?
Yes.
Yes.
Great. My name's Danny Orrock. I work in-house for a software company here in town. I'm engaged to a recent graduate at Northwestern.
Congratulations.
Thank you. And as a former law student, of course, I always welcomed an assignment that contained a concise decision, or at least a short excerpt. As I understand it, I think decisions have gotten a lot longer in the past 10 or 20 years. And I wondered if you could comment on whether you think that making a decision a little bit more concise and shorter necessarily sacrifices the quality.
Not necessarily at all. I don't know whether Supreme Court opinions have gotten shorter or longer or stayed the same. I honestly just don't know the answer to that question. I remember, from 25 years back when I was clerking, I can remember a fair number of opinions that were long and sometimes that were too long. And, I think it varies case by case. I think to the extent that you can make your decisions more concise, yes, absolutely. You don't want to be repetitive, and you don't want to talk about a lot of unnecessary things, and you don't want a lot of clutter. At the same time, there are sometimes, in some cases, that push the opposite way. Really complex cases where if you try to make it too short, you'll leave out crucial parts of what a person needs to really understand the decision. And I think also sometimes the desire to fairly respond to parties' arguments, because you're presented with these briefs. There are credible arguments on the losing side. You want to take those arguments seriously. You don't want to just say, no reason to think about this. Sometimes those arguments really deserve to be engaged with, and the parties deserve to be told why they're losing, notwithstanding those arguments. And that desire, the desire to treat seriously serious arguments, even if they're ultimately not going to prevail, I think is also something that tends to lengthen opinions. So I think that this is a balancing act. I mean, some opinions ought to be really short, and if they're not, you're making a mistake, and some opinions ought to be longer. And if they're too abbreviated, you're making a mistake. But I definitely try to keep in mind, every time I write an opinion, I ask myself the question, can we take anything out? Try to take it out if the answer is yes.
Great, thank you. Please.
My name is Lily Middleman. I'm a current student. You mentioned blogs earlier, and you mentioned blogs earlier, and in recent years there has been commentary in some of these blogs about how, as the court has addressed and expanded protections for LGBT individuals, they've stalled for expanding protections for women. And I was just wondering, do you agree with that assessment? And if so, why do you think that is, and could anything be done to improve it?
I guess I'd rather not talk about what the court is generally doing with respect to particular subject matter areas. For me, it's not very helpful to try to say, oh, we're moving in this direction with respect to this or that direction with respect to some other issue. I like to kind of take it one case at a time, and I might have my own views of what decisions have come down in the past, but I think we usually speak best about those decisions when we speak as judges, when we write opinions. And so from some of my majorities and some of my dissents and some of the majorities and dissents that I've joined what I think about particular issues, and I'm probably not going to improve upon that in an auditorium. And so I guess for me, the decision I've made is to sort of let it rest there.
Thank you. Please.
Oh, great. Hi, thank you. Hello, Justice Kagan. My name is Eunice Bueller. I'm in my final year here at Northwestern Law and will be entering the workforce in a few short months. With that in mind, what sort of practice and life advice do you have for those of us who will be beginning our lives in the law?
Now, what makes you think I'm a good giver of practice and life advice? I don't know. That seems, wow.
That's deep.
That's a heavy responsibility you got there. I will tell you what I used to tell students at my law school, which is there's no one path for all law students. I couldn't give you life advice like go do this because I don't know you and I don't know your interests and I don't know your passions. The only thing that I can tell you is that you should get to know your interests and passions, and you should follow those. I tend to think that law students are too risk-averse. I tend to think that law students too much do whatever they think the next thing to do is, are too afraid of closing doors behind them, are too willing to do things just because all the rest of their classmates are doing them. And that's not to cast aspersion on law students. I'm sure I was exactly the same way. And, of course, not all law students are like that. But I guess to the extent that I have any useful advice to give, it's to, do what moves you, to follow your path, to find the jobs that are going to make you wake up in the morning whistling and ready to go to work. And that's going to be different for all kinds of different people. And but the most important thing in a professional life, and I'll leave the non-professional life really to you, but the most important thing I think in a professional life is to love what you're doing, and not to worry too much about the next thing or the thing after that. To think that the future will probably take care of itself for people like you, for people who have the kind of credentials that you do. that you should just try to find what it is that will really make you happy and fulfilled in the moment, and that when you get a little bit bored of that you look for the next thing to do.
Thank you. Time for just a couple more questions, please.
Hi, Justice Kagan. My name is Connor Tucker. I'm a first-year student here. The first question is, we have the rare distinction of speaking to someone today who's been both the Solicitor General of the United States and now a Supreme Court Justice of the United States. And so what is the biggest difference that you see being on one side of the podium and then asking questions on the other, and then leading into or leading out of that for an aspiring appellate advocate? What do you wish you knew when you were Solicitor General now that you are in the position to judge Solicitor Generals?
Well, the big difference between being on the other side of the podium is that being on the other side of the podium is a lot easier. And I try to keep this in mind, actually, as I listen to arguments, sometimes more successfully than others, I'm sure. But I try to keep in mind how hard it is to be at the podium. And it is really hard in the Supreme Court, where the questions are just coming at you fast and furious, you're being bombarded, all the questions are hard, all the questions are good. At the same time, the justices are kind of having a conversation amongst themselves, and sometimes it seems as though we don't even really care what the person at the podium has to say because we're too busy talking to each other, which also has a purpose and has a use, but it's awfully hard to be the lawyer. It's always hard. It's always easier to ask the questions than to answer them, and as I say, when I say that we have some extraordinary lawyers who appear before this, I mean I think part of the reason why I'm so appreciative of their efforts is and of their incredible skills is because I know how hard it is to do what they do, and it is really hard. I don't know if. Having watched a lot of arguments, I mean, the Solicitor General's office was a great place to learn how to argue cases. There's no better group of lawyers. There's no more skilled set of Supreme Court practitioners, and there's no more generous set of people. And I came to the Solicitor General's office without a great deal of experience. Actually without any experience, let's be frank, in Supreme Court advocacy. And those folks were so generous in teaching me how to do it. And I feel very, very grateful for that. But I don't think that there are any tricks here. I don't think that there's something that, like, suddenly when you're a justice you realize, oh, that's the way to do it. I think it's a really hard, really specialized skill that the Supreme Court is really lucky to have some great practitioners of.
Hi, Justice Kagan. Thank you for your service to the country. My name is Drew Diltz, and he actually just asked the question I was going to ask you. So
think fast.
Instead, I would ask, can you comment a little bit about your interaction with the other justices aside from the meeting where you all sort of discuss your opinions about a case?
Aside from my hunting.
Aside from the hunting.
Yeah. No, I mean, this is, thank you for asking that, because it's one of my frustrations, and I think it's honestly something that we're partially responsible for, is that I think people have not the correct view of the kind of institution that we are, that they see the way we write. And sometimes our majority and dissents can go at each other pretty hard. And you can get this impression of people who are really divided and even don't like each other very much, sworn bitter enemies. And the truth of the matter is, I think that this is a court of great collegiality and of real friendship. We're in an unusual position. There are these 9 of us, and we do this thing that not only the 9 of us do, which is a little bit different from what other judges do, which you can't really talk to anybody about, only to each other about. And there's a kind of bonding that occurs, I think, because of that. And just because I think that there are some magnificent human beings on the court, I think it's a court where there's a lot of warmth and a lot of graciousness, from the top down. And I think that the tone is largely set by the Chief Justice, and this Chief Justice is a very gracious man and a person who really cares about the personal relationships, the civility, and more than that, the real friendship and warmth among the members of the court. So I'll just give you one, little but symbolic story about that. Is that when I was confirmed, it was about 3 o'clock in the afternoon. It was on a weekday. The Senate was voting. I was in the Solicitor General's office with many of my colleagues, kind of watching the proceedings. The phone rings after the 50th vote comes in. Didn't even wait for the end. The phone rings. Pick it up. This is John Roberts. I just wanted to be the first to congratulate you. And this is kind of like a great thing just by itself, but what you have to understand is that the Chief Justice was in Australia at the time, and it was 3 o'clock in the morning there, and he had waited up all night in order to find the exact second when that 50th vote came in, and he was able to call me. And I think that that's very symbolic of the kind of leadership that he brings to bear, the kind of graciousness. And many more of my colleagues, I think, really count that as an important facet of the way the court works, that we all respect each other and like each other, and that we all treat each other every day with the understanding that each of us, no matter how much we disagree, and we disagree strenuously at times and on important matters, but we always know that everybody is operating in good faith and that everybody is trying to get to the right answer, and that everybody is doing that with a tone and an attitude of real respect for the other people on the court, even when they disagree. And I think, we sometimes that's the way we work, but then the way we write doesn't reflect that. And I'm sure that that's true of me. I can write a harsh dissent as well or better than others. I mean, if you put like on a scale of, I can get pretty cutting, and so maybe that's the wrong thing, but it's actually important to know that the court as an institution is a court of really great collegiality and of real respect.
We'll take one last question for the gentleman on the left.
Thank you very much. My name's Charlie. I'm a current student here. I'd love to hear your opinion about the adequacy of the confirmation process as it currently operates, and in particular your opinion of what the implications might be of filibuster reform for the quality and character of Supreme Court justices in the future.
The implications
of filibuster reform.
Well, I think I will not comment on that. I'm not well enough informed, and that's their business, not mine. So Congress can figure that one out for itself. On the confirmation proceedings, I think, honestly, they've become very frustrating for everybody concerned in the process, for nominees, but also for the senators themselves. And I'm not quite sure what to do about that. I think that there's a real disconnect between what the senators want to know about, and I completely understand why they want to know the things that they want to know, but there's a disconnect between what the senators want to know and what the nominees will answer. And in part, that has to do with ethical constraints. There surely are ethical constraints with respect to what nominees will answer. But in part, it also has to do with considerations of it's not usually there are some things that it's not helpful to reveal. If you're a nominee, you want to get confirmed, and bearing your soul is not necessarily the way to do that. And bearing your soul over the things that the senators want to know about. The senators basically want to know about results. They want to know how you're going to vote on the issues that they most care about. And the nominees are, I think, not going to be very forthcoming with respect to that. And so you do have this situation where they're kind of operating like this. You know, when I went through the confirmation process, the promise that I made to myself, and I talked about to the White House aides, who of course are an integral part of this process, is that I would talk as much as anybody wanted to talk about my approach towards constitutional interpretation, my views about constitutional interpretation, my views about statutory interpretation, my views about judging and what it meant to be a good judge and the qualities of a good judge, even as I would not basically say, you know, this is what I think of this case and this is what I think of that case and this is how I'm going to rule on this kind of case and that kind of case. And in point of fact, you know, I found that the senators were not all that interested in having the kind of conversation that I was ready to have. And I understand that. I mean, if I were a senator, I'm not sure I'd be all that interested in it either. That I might be more interested in, like, yeah, but there is this set of issues that I really care about, and I want to kind of know, I want to kind of be able to figure out what you're going to do on that set of issues. And so there is this just real disconnect. And I don't have, like, a great magic wand kind of solution for it. I mean, I won't, just to make this clear, when I say that there's frustration about the process, I actually enjoyed the process. I mean, 82 courtesy visits was maybe a little bit much, but it was actually extremely interesting to go around to senators' offices and to get to know them and to learn about them and to learn about their interests, learn about what they thought was important. Quite often, the conversations I had with senators, which, by the way, were, without exception, courtesy visits was right. They were, without exception, courteous. They were often, I thought, the senators were extremely intelligent, extremely well-informed. Sometimes people who I had sort of pegged in a certain way didn't seem to me to be that way at all. I thought it was really eye-opening and educational for me. And I also liked the confirmation process, the hearings themselves. I mean, as you might be able to tell, there's a little piece of me that's a little ham, you know? And you put me on a stage, and you say, okay, now you can talk. And it was kind of great. They can't really interrupt you. And I like talking about law, so that was good. And I took it as a little bit of a challenge to be able to talk about law in a way that was at least vaguely interesting and occasionally funny. And I enjoyed it. I did. But I think to the extent that it's supposed to be a way of people really figuring out something or about the nominees, it doesn't really serve that function, because what the things that the senators really want to know are the things that the nominees are not really going to tell them.
Right. Well, I want to, after we're done, invite the speakers who ran out of time to come up and ask the justices your questions. But first, let me invite all of you to our reception in the atrium. And last but certainly not least, let us again thank Justice Elena Kagan for taking the time.